where we are going to spend just an hour or so talking in depth about one kind of topic. And one of the topics that we thought would be really useful to JDTC teams is information sharing and MOUs. This webinar is brought to you by the National Association of Drug Court Professionals and the National Council of Juvenile and Family Court Judges. We are your training and technical assistance providers. So if you have need for training and technical assistance, we're the folks to talk to. We are, of course, funded by the federal government, and so any positions that are talked about today represent those of the presenters and not of the federal government. So now as we have prosecutors, defense attorneys, lots of coordinators, of course, because this is part of your milieu as your responsibilities, some probation, an evaluator, treatment, and court administration. So we really appreciate you all being here today. It is my great pleasure now to introduce our faculty member for today, Dr. Bridget Ortega from John Marshall Law School. Bridget has been a trainer for the National Council and for NADCP for a number of years now, possibly more than a decade. Actually, I'm sure more than a decade, and also was part of a JDTC program when she was a public defender. And we are very, very excited to have her here to talk with us about information sharing. So without further ado, Bridget.
Thank you, Jessica. I am thrilled to be here. And we're going to be talking about MOUs, information sharing, and how that relates to the team. I want you to know that first of all, I want to thank the National Council of Juvenile and Family Court Judges and also NADCP for hosting these Tune-In Tuesdays. It's a fabulous idea, and it's a great way for you to get some training, high-level training in some situations and more detailed training in others. I want you to know that this training is not a substitute for legal advice. I'm going to be talking about legal concepts, but if you have specific questions as they relate to your team, you really should seek out legal counsel. And you have them on your team, and you also probably have them in your county. So please do that. No, this is not a substitute for that, but it's pretty high level learning. Today is all about sharing information, how to do that safely, how to do it legally, and how to do it confidentially. So it is really, really important that you understand that confidentiality laws do apply in your juvenile treatment court and on a lot of different levels, and we're going to address them. So I want to start by talking about why should we share information in the first place? What's the whole point of sharing information? And it may seem like a no-brainer, but one of the most frequently cited problems we have in delivering comprehensive integrated services in our juvenile court generally, and in JDTC specifically, is lack of information sharing among the agencies. This is especially true in collaborative courts, which, if you think about it, by their very design are dependent upon collaboration between agencies. You know, many families and young people who come into these courts have difficulties. They have risk factors, and they may have multiple histories that exist in multiple systems. And knowing this history can lead you to make more informed decisions about what to do as you're working with them. They may have a medical problem that could shed light on their behavior. They could have school-related issues or prior brushes with the law. And it's more probable than not that the people we're working with have been in more than one social service system, and they could be receiving services from multiple agencies. I know that was the case in our court. So it's important that we understand people in the context of their environment and in the context of their family. But that can facilitate delivery of services, but it also can increase the responsiveness to their needs. Sharing information also serves as a cross-check for us, you know, for the veracity and legitimacy of the information that's coming into the court. And so all of these are legitimate and important reasons to share information about young people. But one of the often overlooked reasons is it strengthens the team. We know from research that if you as a team identify common goals, agree to share resources and information, and coordinate effectively as a team, then you're going to experience great success with the young people that you're working with. Your interventions should work. So as highlighted in the JDTC guidelines, they want all of the stakeholders to collaborate to find innovative and effective strategies to address problems. So you can't do that without effective information sharing. You just have to be able to share information. So what gets in the way? Well, a lot of things. Policies and procedures, sometimes that prohibit sharing information. And sometimes organizations are confused about that. They'll put up barriers because they're fearful about what's going to happen with that information, or they're afraid of liability for disclosing it. Sometimes the information is in a database or a file cabinet or a file room, and there's no easy access to it, and no mechanism for getting the information out, and no procedure for who gets what. I know I see all the time that, there's some really rich nuggets at intake in some jurisdictions where they gather all of this really wonderful information, but it's only used for a very narrow purpose. And then it's filed away or tucked away somewhere until the next time. But we don't really make use of that information because we don't have a procedure for getting it to people, other than maybe the judge for detention purposes. Sometimes the information is confidential and the client doesn't want it disclosed. They may have a privilege, like the attorney-client privilege, which is an ethical duty. Other disciplines within your team have ethical duties and legal duties to handle information in a certain way. Those of you who have an education resource, right, they're governed by FERPA, the Family Educational Rights and Privacy Act. Your treatment providers, they're guided by 42 CFR and HIPAA. And so they have legal responsibilities and legal requirements that say, no, we cannot share certain information unless there has been consent. And we're going to get into that. A lot of people won't share information about a participant for fear of what the person is going to do with that information. And they don't trust or respect the recipient. Now, I'm a former public defender, and I can tell you, we are not the most trustful people in the world, okay? And we're very, very protective of the information that we have that involves our clients. And even with the agreements that we have to participate in these courts. So there are, trust is a real big issue. And the more you as a team learn one another and learn to trust one another, you'll be more inclined to share information. Principle of confidentiality, what I want you to understand is about privacy and respecting a person's wishes. It means that professionals should not share information, personal details about someone with others, unless that person has said they can and it's absolutely necessary. And just because they are in a juvenile drug treatment court does not mean that it's an open field for that we can do any and everything that we want to do with their information or with them. So confidentiality is the ethical and sometimes legal obligation, as I said, to respect a person's privacy. And privacy refers to the right of a person to decide what information about themselves will be shared and withheld from others. If something is confidential, it has been given in confidence. Think about it. that means that it's in trust that it will be kept secret. The root of the word is confide, or to tell someone a secret, and often reluctantly. Confidentiality is not only about respecting that right, but it's to protect from disclosure unless they authorize it, meaning give consent for you to disclose it. The law also protects what's known as confidentiality. Laws protect privileges, attorney-client privilege, marital privilege, doctor-patient privilege, client-therapist privilege. These communications cannot be disclosed even in a court of law without the permission of the person who holds the privilege. And now there are ways around that, you know, with subpoenas and things of that nature, but there has to be a very strong and compelling reason to for a court to allow it. Confidentiality also helps with trust. That was the impetus of the question that I asked. Who do you know that would be willing to open up and tell some of the most detailed and intimate aspects of their lives, especially when they've messed up, okay? Knowing that it can be communicated to anyone or at any time. Nobody wants that. This expectation of privacy helps our relationships, especially the ones that we're in with our participants and our clients. The whole idea is to prevent information disclosure over a person's objection, especially if it does not serve their best interest. And it's a problem that our laws acknowledge. I know what you're thinking, all these rules and regulations. So how do we get the information that we need? After all, multidisciplinary team communication is crucial to what we do, right? So all of the team members' perspectives are important and critical to the success of the people we're serving. So fear not, there are ways to get what we need when we need it. So there are 3 legal bases for disclosure of confirmation, I'm sorry. Statute, consent, and public interest, right? One way we disclose is in response to the law, right? A court order. So there are legal routes available to providing alternatives to consent where consent is not practical or it would be inappropriate. Mandated reporting is an example, right? And many of you that are on this call are mandated reporters. You are required by law to report all known or suspected cases of child abuse or neglect. If a person is a harm to themselves, a threat to themselves, or a threat to others, the law mandates that you disclose that information. And that's a public interest. That's in the interest of the public that we do that. Most decisions to disclose on public interest grounds fail because the courts are weighing the public interest to disclose against the individual's private interest not to disclose. So when it makes its way to court, that's what they're going to be looking at. They're going to weigh those 2 things. And its public interest test is rarely sufficient to warrant disclosure when the person is available and seeking consent is feasible. If consent is feasible and not appropriate, then consent is the route that should be taken. So there are ways to get the information. And I know in our treatment courts, a lot of times we will have them sign a general consent form. That form sometimes has every possible stakeholders agency listed, and it discloses to the client that we are going to share information amongst ourselves. So let's talk about consent a little bit. There's 2 types of consent. There's informed consent and there's explicit consent. Informed consent is the proper mechanism for exchanging information about the families and the young people that we work with. It requires a written release, signed by the individual or parent or legal guardian of a juvenile under the age of majority, and the person has to have an understanding of what is being asked of them. So any consent form that you are presenting to a youth or their family, it needs to have what information is to be shared, who it's to be shared with, what's the purpose of sharing it. You also need to state in that form what happens if they refuse to consent. If they refuse to consent, then usually what happens is they're not eligible for the services that you are willing to provide. The consent form also has to have an opportunity to withdraw at any time, and it should have a statement about no redisclosure unless specified. That means information that's given, you can't then turn around and give it to someone else unless it's specified in this consent form. So remember I said that the principle of confidentiality is about privacy and respecting someone's wishes. It means that professionals shouldn't share personal details about someone with others unless that person has said they can or it's absolutely necessary. So here are some ground rules to help you share information within your team confidently, appropriately, and proactively. So this will help you create better links between the services for the good of the people you're serving and you getting the information that you need to be able to continue that service. So as I go through these, remember the idea is not to put up barriers to prevent information. It's to knock down barriers. I want to make sure that that sharing is safe, secure, and legal. So the first principle of privacy law, confidentiality law, is there a need to know? We as practitioners, and I know because I am one or was one, I was in the trenches just like you guys, we're nosy by nature, okay? But we don't need to know everything about everyone. Consider the outcomes as a provider of the information, or as the asker, right? What will happen if I share this information? What will happen if I do not? These are questions you should be asking to determine whether you should share or how much you should share. Sharing is justified if it's clearly in the best interest of the youth and the family and the subject of the information or the person to whom the information belongs. The information shared should be what is minimally necessary to achieve the purpose it is intended for. Where I've seen this come up is primarily with defense attorneys and also with treatment providers. You know, how much information should they share? Treatment providers, usually that information is going to be at a very high level, right? Are they attending group? Are they participating? Are they engaged? That kind of information. If they've signed on to your consent form, if they are a member of that consent, and recognize that they have their own consent forms internally, and that's the case with many agencies, right? So they have to make sure that the information that they're sharing complies with both the court's consent form, the JDTC's consent form, as well as their internal consent form. But the information really should be high level for treatment providers. They are not going to get, nor should they, get into, you know, the details of their therapy, the details of what's going on. The same with mental health providers. They should not be disclosing that because HIPAA forbids it. Is the information privileged? Attorney-client privilege. I will tell you that even if an attorney signs that form, a defense attorney signs that form, the privilege trumps any disclosure, right? So if the client is not willing to allow the attorney to disclose the information, they will probably not be able to disclose it because they are barred ethically And they're not going to trade their bar card for participation in a juvenile drug treatment court, nor should they. So the information shared should be what is minimally necessary to achieve the purpose it is intended for. And I'm going to get through this so that you have some time for questions, because usually that's where the questions come up. Is the information up to date and accurate? Is it opinion or is it fact? A lot of times we run into problems with information sharing because the information is not accurate, or it's incomplete, or because an opinion is stated as a fact. Consider the source from which the information originated and ask yourself, is it likely to be reliable? Do you have good routines for checking the reliability of the information that's coming into the court? It's often worth checking factual information about a person with the person before you share it. And this can be done by letting the person see a report before it's sent or shared. Reliability is an issue. So you want to make sure that the information you're receiving is accurate and up to date. Information belongs to the agency or person that supplies it. It belongs to them. It should not be passed to third parties without consent. Information gathered for one purpose should not be used and then passed on for another purpose without consent. In our multidisciplinary settings, usually we have a general release form. It includes all the team members on it and a general description of the information to be shared. And if you have an MOU, it really should have a provision in it about information sharing. When the person signs the release form, they need to understand what they are agreeing to. If an organization or a new partner comes on board and they're not on the release, then you cannot share information with them. Many of your organizations will have their own release forms, especially therapists, as I mentioned before, doctors. There are things that they cannot share with you. Make sure that these forms are not inconsistent and everyone understands what they can or cannot share. Consent should not be assumed. Make sure you go through the consent or release form carefully. If circumstances change, maybe living arrangements, maybe parents or guardians change, be sure to revisit consent. Also remember that consent to disclosure of personal information should not be viewed as lasting forever. It's finite. A person may choose to withdraw consent previously given, and that should be stated in the consent form. It's a requirement. It's a legal requirement. It's really important that you keep a record of what information has been shared and with whom it's been shared with, when it was shared and for what purpose. It's not necessary to keep separate records or informal of, however, it is, you should have an event sheet that notes conversations, informal context, etc. If a report is given, it should be noted who it's given to and why. You know, I'll give you an example. I did a research project just a few years ago, and during that research project, I actually visited drug courts and other collaborative courts. And in the process of doing that, I also was granted permission to attend their staffings. And so I sat in the staffing and I listened to the team talk about the individuals that were going to be appearing in court that day. And I would say only half of the people out of the 32 courts that I visited, only half of them had me sign a non-disclosure agreement. And I would say the other half that did not, and I even asked the ones that did not, and they said, oh no, not a problem. That's an improper sharing of confidential information. Now, what goes on in the courtroom is public, okay, because these were adult courts. And that's public information. So what's going on, anyone can pretty much go into a public courtroom. But in a juvenile court, but what's going on in those staffings in that back room where you're talking about these people and sharing very specific information, that is not public information. And I doubt very seriously that, and it's an improper third-party disclosure because I'm in the room. So I did note that to the individuals that I met with, and I spoke to the judges about that so that they would have this information for their own purposes for the future. Be sure that you're not in earshot of other staff members or members of the public who may not have a need to know. Okay, it's really important that you do that. Be aware that informal information sharing may not be compliant with statutory requirements as well. You also need to know that these hallway conversations can be risky. These informal verbal conversations that are temporary, you know, there's no documentation, there's no record, and they're hallway conversations, they're trusted relationships across the agency. I want you to just be aware that you could be violating the law. And it's really, really important that you be aware of that. So I want to talk a little bit about collaborative, a process that you can go through. And I think there's well, I know there's a publication because I wrote it. There's a publication on this that's on the National Council of Juvenile and Family Court Judges website. It's called the 7 Steps to Collaborative Information Sharing. And these are just some things for you to keep in mind, right? Because it's about privacy and respecting people's wishes. It means that professionals, again, shouldn't share personal details unless that person has said they can, or it's absolutely necessary. So the first thing you should probably do for all of you newbies and others, if they haven't done this, is to create an information sharing stakeholder group. You know, you need to sit down and figure out what information is it that I need to be able to do my job as a member of this team. That's the overarching question. And the group, the stakeholder group, should have a representative from all the participating agencies. You really should have a youth and family advocate on that stakeholder group as well. And it's designed, they designed the process for sharing information at the operational level, right? The policies that will guide the team in terms of information sharing. And they also would be responsible for doing this kind of training, right? As the law changes, you know, HIPAA is constantly adding things, FERPA, things like that, they would do that training for your team and new team members that come on. They would resolve conflicts. You know, if one stakeholder says, I can't give you that, and this is the reason why, then this group, this stakeholder information sharing group would be the one that resolves the conflict around that. The idea is to provide clear and concise guidance to all of the team members about what can and what cannot be shared. Now, you noticed I said youth and family advocates should be a part of this. They're important to this group because they are moving in and out of multiple systems, each of which collects information. They can advise you about who is collecting what and about duplicative efforts. And so having someone as a family advocate participate in this process would be very helpful to you. Think about what information is currently being collected. A lot of information is collected currently it's regulated by statute. You know, does that statute target a specific type of information or situation? It's most important within your own agency to understand what you can and cannot share. and the laws that govern that information. You've heard me talk about 42 CFR, FERPA, HIPAA. Those laws are very specific about what can be shared and what cannot be shared. But it doesn't prohibit you from being able to do the job that you're called on to do. And a lot of times, even in those situations, a very clear, specific release form will, or consent form will enable them to be able to share that information. Identify what needs to be shared and to whom. This gets back to the need to know, right? So you're going to ask yourself, is the information confidential? Once you've decided what information you want, is the information confidential? Are there exceptions to any confidentiality restrictions? Under what conditions should that information be shared? Who needs to know? Can it be shared without consent? It's really important to understand what can and cannot be shared in this context. As indicated in one of our earlier scenarios, certain team members may have a duty not to disclose, certain types of information. All right. Enter into, once you've figured that out, don't leave information sharing out of your MOU. You should have a memorandum of understanding that's signed by all participating team members, and I'm sure most of you do. But in that MOU itself, you should be talking about what information will be shared, how it will be shared, who will have access to it, and assurances that there will be no third-party disclosures. It should be grounded in informed consent, and it should formalize the agency-to-agency conditions for disclosure. The MOU makes it possible for agencies to share information without violating the privacy of youth and their families. And the MOU, like the informed consent form, should be reviewed periodically to ensure that it actually accomplishes what it's designed to do, and it protects the privacy of the youth and family. And I know a lot of times you all have members that are coming in and out of your process, going, changing jobs, judges rotate, things of that nature. You have to go back and revisit your MOU and your consent forms when that happens. The reason you have to do that is because that consent form is signed by an individual, not an agency. And so the individuals that sign that consent form are agreeing, that have signed up to share this information on the MOU. They're agreeing, they're signing, they have the authority of their agency to sign it, but they don't, they're signing as an individual, not as the agency. They're a representative of the agency, but you can't just slot another person in there because they need to know all of the provisions that are stated. I hope that makes sense. Cross-training is important. Everyone should have a policy and procedure manual that spells out the information sharing process for the team. If you don't have one, I strongly recommend that you create one. And each member of the team should be trained on the privacy policies and practices of each agency participating on the team. Then review your information sharing and confidentiality provisions regularly, train new team members, get them to sign on, policy and procedure manual, and keep abreast of changes in the law. Privacy policies and law may change. You may decide that someone else might have to solicit informed consent for the team. You may change treatment providers. Things change. And so as things change, you need to make sure that your information sharing and confidentiality provisions are still accurate. A high level of trust, honestly, among your team is really the way to achieve cooperation here. And it's not just trust with your team, but trust with the young people that you're, trust with the families and the young people that you are serving. And although we have protections established to protect individual privacy, the laws are not intended to stop the team from communicating with one another. It may have sounded like it, but that is not the intent of the law. There's simply protections against improper sharing of information over a person's objection or that does not serve their best interest. That is the purpose of the law. And the protection of personal privacy and delivery of services through collaborative information sharing, these are not mutually exclusive goals. They can be accomplished together. So a couple of closing thoughts I have for you. Sharing information is very important in these courts, and you can share with appropriate consent. You need to understand your own area of expertise and what your internal individual policies are, and then match them against the policies of the Juvenile Drug Treatment Court itself and make sure that they're consistent. And it is possible to share safely, legally, and with respect for confidentiality. Treatment providers, again, should share high-level information that will support the court and the team in determining a course of action moving forward. Treatment recommendations should come from treatment providers only. Remember, attorneys cannot share confidential client information. It is protected by privilege. And probation should share information as needed to support appropriate assessment of the situation and recommendations. It's all about the team. And as a team, I'm sure that you can come up with policies and procedures that will get you to where you want to go. That's all I have, folks, for you today. And I think we have a little bit of time for questions. Is that right, Jessica?
Yes, we have about 12 minutes left, so we can do about 10 minutes of questions and 2 minutes of wrap up. So I've asked folks to put questions into chat. And so we're hoping that as questions have come up, people will put them in chat. So can you, it sounds like one of the things that you're really recommending is that people be really deliberate about information sharing and that this becomes something that they're really thinking about rather than sort of doing it ad hoc. I think about your example with the public defender not telling them about Johnny's drug test. I can imagine the rest of the team kind of getting mad about that.
Right.
And so we want to make sure that everybody on the team knows about those things before we get to that place, so there isn't that argument.
Mm-hmm. That is correct. That is correct. I absolutely am asking people to be intentional and to think through these things in advance so it does not become a problem. And even as a public defender, you know what I mean? There are, I mean, if you think about it, there are ways, and I don't encourage people disclosing, you know what I mean, confidential information, but, you know, the public defender gets to make suggestions, you know, and gets to can do that in a way that's still very mindful of their client. They can still, you know, serve their best interests without necessarily disclosing or breaking that trust or confidentiality. There are ways.
All right, so another question that's come into chat: should defense attorneys vote on sanctions?
Should defense attorney, that's a different topic, but absolutely, absolutely. I don't think that's inconsistent. And I think that's something that should be disclosed to your client, you know what I mean, at the beginning, when they're coming in and you're having that conversation about how treatment court works that it is a collaborative process, that we do share information, that I do have a say-so about what's going to happen to you. You know what I mean? Going forward, it's not just, I don't see how we cannot, have a say-so on sanctions and incentives.
Well, and I think that if we're doing a really good job with the young person, with getting their input on what's going to happen, and that they're really clear on their plan, they should probably know what the sanction is going to be long before it's imposed by the team, right? We don't want that to be a surprise.
Absolutely.
We don't want them to be like, what? I didn't know I was going to get sanctioned for this. And so that's a great time for the defense attorney to do that messaging of, you were aware that if you went to the Cinco de Mayo party and you smoked, that you were going to get a sanction. You made that choice. So now we're giving you the sanction that you kind of knew was coming.
Right.
That's a natural consequence of life, right? And so the defense attorney gets to play sort of a different role there then.
The defense attorney also gets a chance, not to beat a dead horse, but the defense attorney also gets a chance to help that young person come up with an incentive and sanction that might work for them.
Yes,
Because
we want their voice and choice as much as we can, and defense attorney do that.
Absolutely.
So a question has come in to say, is there a standardized or recommended MOU format / content that can be shared? And I think we do have a couple of those forms that we can provide. After the webinar, then for everybody, we'll sort of send out a little package saying, thank you for participating, and here's all of the materials, as well as a link to this recording, because I know you probably have team members who couldn't make it today, and you're thinking, boy, our attorneys didn't come to this webinar, but they probably should watch it. So we're going to make sure you have it so they can.
Any other?
So here's a long one. Can an appointment letter with a clause that includes confidentiality, which is signed by all members of the JDTC team, be considered?
Appointment letter.
Mm-hmm.
I'm not sure what that is. I need clarification.
Okay. So Allison, if you can tell us what you mean by appointment letter. One of the things I thought that was interesting that you said too, is that the team member, the individual, the actual person themselves should be the ones who are signing these forms. But we do want to have agency level agreements as well.
We do.
So there's two different levels of agreements.
That's correct. That's correct. And I know when I was in juvenile drug court, I mean, I could not sign that agreement without the authority, having the authority of my office behind me. And I think that's the case in most situations. You're not going to go to the boss every time, so you're going to have the higher level agreements, but you're also going to have the day-to-day agreements as well.
Well, and when you're talking about that kind of panel that would maybe be thinking about what the information sharing looks like, maybe that's where you have agency level folks who have already kind of had those conversations in that business meeting kind of way to think about how the JDTC runs. And then the line level folks don't have to worry about that part.
Absolutely. Absolutely. Did we get clarification on the letter?
I was looking, I didn't see it. Let's see. Okay, so yes, she says our laws require that the person on the team are appointed by the registrar of the court. So we create an appointment letter that includes clauses which the person on the team would need to adhere to.
Mm-hmm.
So that's the clarification.
Okay, so that would be a good place to import confidentiality and information sharing agreements. It could happen, you know what I mean, at that level. Yes.
Can you tell me how often, when we're thinking about that agency level sort of sign off on participation in the JDTC, how often those should be changed? I know I go to visit courts and they're like, yeah, we have an MOU with our prosecutor's office. I think they put it in place 10 years ago. Is that okay that it's just kind of malingering there for a decade?
It depends. If it works for you, then it's probably okay. But a lot of times what will happen is the reverse, right? You'll get a change in administration, especially in the prosecutor's office, since it's an elected position in many places, and they have a totally different philosophy about how this should work. And so then your MOU gets jacked.
Right.
Or so and people are reluctant to even show them what the MOU is, and so they'll just keep working. So you know, it gets sticky, but realistically, you need to revisit it on a regular basis to make sure that everyone is bought in.
And so
That's for your own protection, if nothing else.
And so coordinators, you should have kind of a tickler file of, you know, once a year or once every other year, you're checking and making sure everything's up to date to make sure the entire team is protected and the integrity of the program is protected. All right.
I
don't see
I see a
anything
question.
else. You do?
Yes.
Oh, in our Q&A pod. I didn't see that over there.
What should the social worker do in the best interest of the child?
So Bridget, everybody can't see this question.
Okay,
I think we have to read it to everybody.
Oh, that's because it's in the Q&A, right?
Yeah.
It says, what about a child who disclosed he or she was raped and do not wish to disclose to their parents, but disclosed to a social worker, and the social worker encouraged the child to disclose? What should the social worker do in the best interest of the child? Social workers are mandated reporters, right? So you're a mandated reporter. So once you report, you know, start that legal mechanism, there's no way that the parents are not gonna know. You know what I'm saying? So it would not be a violation. It would not be a violation on a couple of different levels. One, the legal requirement to disclose, and two, it's in the best interest, right? It's in the public interest that that disclosure be made. So on both of those grounds, you would not be, and the social worker needs to let the child that they have an obligation to share that information.
Yeah, I think that's one of the big things for mandatory reporters is that, you know, they get a lot of training sort of on how to make sure that the person who's disclosing knows that it can't remain confidential because of the nature of the information.
Okay. So we have another one. If a minor reports they are pregnant, should it be disclosed to the team? It depends on how your consent form is structured. Okay. So remember I said all disclosures can be cured. Well, most disclosures can be cured by consent, right? So it really depends on how your consent form is structured. That consent form that the child signs that has all of the participants, you know, listed on it, right? So the young person knows that information is going to be shared with the team. And again, it does depend on who they're disclosing it to. If they disclose it to the defense attorney and say, I don't want the team to know this, the defense attorney is not going to be able to disclose that. If they disclose it to the probation officer, probably the probation officer can't disclose it to the team, depending on what the provision is in the consent form that they sign. And that provision should probably, I'm trying to pull up not an MOU, but a consent form. I have a sample consent form that talks about, you know, health matters, that talks about, you know what I mean, things that have to do with the health and well-being of the young participant. So it depends on really what the language is. So remember, the consent is that young person should be on notice that that information is going to be disclosed. That there are no secrets, especially as it relates to their health and well-being. Though there will be no secrets, but they should know that in advance. Right. So that shouldn't be a surprise to young people, and especially if they're in your court and they've been using. So.
Yeah, that definitely is one of those kind of ethical dilemma questions where it's, you know, thinking about why would the team need to know and what you're going to use that information for and how to move forward. I think it's lots of things to think about there.
Thank you all for participating.
Thanks for talking with us about this, Bridget. I think it is such a core part of the JDTC and the team approach to have good mechanisms for sharing information. But I think it can feel really like an afterthought for most folks because you get really excited about the kind of cool parts of the program, you know, like the incentives and sanctions and like seeing kids transform. And we forget a little bit about these things, webinars. All right. Thanks, everybody, and have a wonderful rest of your day. And we'll see you in June.